The ultimate goal of legal research is to find the relevant primary law that governs your legal issue. Ideally, you're looking for mandatory authority, which is primary law that's binding on the court you were appearing before. For this reason, mandatory authority is often used interchangeably with binding authority. For 3 of the 4 sources of American law, it's easy to determine whether that law is binding on your claim. Generally, these types of laws, constitutions, statutes, and regulations, tend to either be mandatory or irrelevant because they either apply or they don't to the issue that you're arguing. But whether a judicial opinion provides mandatory authority is a bit more complicated and informed by the doctrine of stare decisis, which is Latin for let the decision stand. The doctrine of stare decisis stands for the premise that similar cases ought to be similarly decided, and therefore the decisions of higher courts take precedence over the decision of lower courts. This promotes stability in the law, and as a result, parties and attorneys can predict whether conduct is lawful or unlawful. Effectively, this means both the state and federal court systems have a hierarchy of courts that bind the courts below. For example, the federal system has 3 distinct levels. The lowest courts are the United States district courts. This is where most cases begin. From the district court, an unhappy litigant may wish to appeal their claim to the Intermediate Appeals Court, the U.S. Court of Appeals. The U.S. Courts of Appeals are divided into 11 separate courts that cover certain geographic areas of the nation, as you can see here on this map. But notably, the appeals courts only have jurisdiction over claims arising out of the district courts in their corresponding states. Finally, in some cases, a claim may travel all the way to the U.S. Supreme Court and ultimately become the highest authority in the country. At the state level, the court systems function the same, with the U.S. Supreme Court acting as the highest authority in certain circumstances. Using your understanding of stare decisis and the court hierarchy as a guide, you can determine if a case provides mandatory authority using 2 steps: consideration of choice of law and venue. When considering the choice of law, you should think about whether the legal issue in your case is governed by state or federal law, or perhaps a combination of both. This is important because the case law precedent must apply the same jurisdiction's law as it would apply to the controversy at hand. When considering venue, think about what court you may appear before. Will you be in federal or state court? And are you arguing at the trial or appellate level? To make this a bit easier to understand, let's look at some examples. Let's say you have a client who wants to file a gender discrimination lawsuit against her employer in a federal district court located in Washington. Assume each of these 4 primary laws are applicable to the facts of your client's claim. As a federal statute, the first law, Title VII of the Civil Rights Act, provides mandatory authority over your federal gender discrimination claim. That one's pretty easy. The second primary law, the U.S. Supreme Court case, is also mandatory authority because it considers the same federal law issue and acts as the highest court authority in the nation. The third primary law, the case out of the Ninth Circuit Court of Appeals, is only mandatory if the Ninth Circuit is the appeals court that governs the geographic region where you initiated your claim in district court. Going back to this geographic boundaries map, we can see Washington is included in the Ninth Circuit's geographic boundaries. And as a result, that Ninth Circuit case provides mandatory or binding authority on your client's claim. The fourth primary law is a case opinion from a federal district court out of the District of Columbia. This law is not binding on your client's claim for 2 reasons. First, it comes from a venue outside of your applicable jurisdiction. And second, to be binding, the case must come from a higher court, such as the Ninth Circuit Court of Appeals. Now let's think about the same issue, but instead consider the claim made under Washington state law and appearing before a Washington state trial court. The first primary law is Washington's law against discrimination. This is a state statute and mandatory authority on your state law claim. The second primary law is a case from the Supreme Court of Washington. Given this is the highest court in the state, the second law also acts as mandatory authority. The third primary law is also binding on your client's state law claim because it comes from the Washington Court of Appeals, and cases from appeals courts are binding on the claims made in state trial courts. But this time, the fourth primary law, which is that same case from the Ninth Circuit referenced previously, it's not binding on your claim because it considers federal law and it comes out of a federal venue. Of course, you can also argue a state law claim in a federal court or a federal claim in a state court, but the rules for those circumstances are a bit too complicated for this video. And in the end, if you cannot find any mandatory authority for your future claims, you may have to use persuasive authority. Think of persuasive authority as just that, persuasive, and it could be any law that is not already mandatory or binding. If a primary law is not binding on your claim, you can maybe use that law to persuade a court. Secondary sources are also used as persuasive authority, and the examples listed here are just some ways you can persuade a court to rule your way in the absence of mandatory authority.